Roger P. Foley, and I'm going to talk to you about a course that I'm taking, a continuing legal education, and where they're talking about disparative sentencing throughout the state of Florida. Now, you hear about, make sure I get this off, you hear about unequal, disparative sentencing all the time, right? You know, in the news, you know, a young black male was sentenced to 15 years when his white counterpart was sentenced to 10 years, right? That is sentencing disparity. When the charges are the same, there's never facts that are the same because every case is different, right? There's never facts that are same, but there's charges that are the same. And what some people, right, in the legal community, they're talking about changing that where there's an equal hand. Well, how do they get an equal hand in sentencing? How do we make, you know, the judge in Palm Beach in courtroom, you know, 11A be the same as the judge in courtroom B, 11B? Well, the reality is apparently there's already case law to help with that. And what they do is on each of these cases, right, there's a score sheet, especially on felony cases. There's a Florida Criminal Punishment Code and there's a score sheet. And what's supposed to happen is that score sheet is signed by the judge, goes to the clerk and the Department of Corrections puts some forms out. And apparently there's a way for defense attorneys to acquire that information. Now, it's just thousands of pages, right? Because it's every case throughout the state of Florida. And then what this one attorney that was talking about disparity to CLE, apparently there's some programs like ESOS, something to that effect, the terminology. It's a program that was developed in 2018. And what it does is all this information, you can put it into it, and then it can separate by county, by judge, right? Like the different sentencing and disparities. The problem with that argument, I see, is I think similar to the minimum mandatory sentences. Because I was also recently, you know, talking to someone about minimum mandatory sentences and how they recently said that was not constitutional. And why is it not constitutional? I'm going to talk about two subjects, and I'm going to show you the parallel in my logic. All right. So mandatories, drug trafficking, you know, human trafficking, whatever. There's a lot of minimum mandatory sentences. So now the courts of the Florida Supreme Court has said, hey, you know what? If you have a fact pattern, when you do these minimum mandatory sentences, the courts, the judge has to have discretion, because how many times do you hear a judge saying, listen, you know, my hands are tied. I can't change your sentence. You have a minimum mandatory sentence. And for years, I've told clients that on drug trafficking cases. I've handled a lot of drug trafficking cases. I said, listen, if the prosecutor doesn't vary from the minimum mandatory sentence, the judge has no discretion. So if the prosecutor says, hey, it's a 3-year minimum mandatory, you could have the governor come in, your priest, your mom, your dad, your best friend, I don't know, a bunch of ethical people from the community, business leaders, political leaders, but the judge's hands are tied because there's, just breaking a little too ahead of the light. The judge doesn't have the discretion because it's a minimum mandatory sentence. Well, now the court has said, hey, that's not constitutional. Anytime you take discretion away, listen to this argument. Anytime you take discretion away, and I'm almost contemplating writing an argument on this, right? The second you take discretion away from a judge, right, to go, hey, well, little Johnny was here, or this fact was this, or this fact was that, it's not constitutional because judges are supposed to have discretion. All right, so now I go back to the CLE that I'm currently taking, right? Well, this attorney is talking about, and apparently there's a whole movement, right? We're always seeing in the news disparative sentences, unequal sentences. The young Hispanic man, he gets 15 years of prison, but the white male, gets 5 years of prison. It's disparative. It's unequal treatment. Well, this attorney and lots of other attorneys are saying, listen, we have programs. You can get all of this information, right, through legislature, through the courts and the Department of Corrections, and you can see all of these sentences on every single charge. And we think, and in my mind, as the speaker was talking about this, because I watched something, Chat GPT is real big right now, and there's artificial intelligence, and there's a movement, there's some cases out, and there's already programs out to like be your own lawyer with, programs like a Chat GPT, right? Where it prepares arguments. Right now it's preparing arguments for non-lawyers on certain types of cases. And I go back in my mind to Professor Massey in civil procedure at University of Miami, and I don't know, was that 2001, whenever I had her. There's no, cases are different. You can't just have a generalized motion. You can't have a generalized sentencing. Every case is different, and there's facts that are different. So if the Supreme Court has already said that taking discretion away from judges is not constitutional, if you were to use this program Esau, right, and I know that that's not what the speaker's intending, right, but I think it's a collateral consequence. Now judges are going to look at it and go, okay, well, maybe I was about to give this guy 15 years, but I see that the average, in this jurisdiction is 5 years. Okay, well, that's a good thing for the defendant, right? But what about the case where they have a shit attorney, or the jury reads it wrong, or right, and the judge sees the facts? Well, if he's going into this, where's his discretion going? Basically, the way that the speaker was saying it, and again, maybe he didn't intend it this way. I'm thinking of a checkout counter, like, hey, a bag of bread is this much, a bottle of Coke is this much. Okay, so if you get a possession of cocaine, you get a year in jail. If you have a drug trafficking case, you get 3 years prison. Everybody gets the same. But the problem is there's, I don't know, aggravating factors that they're not taking into account. They're trying to just make it, hey, everybody gets the same sentence. I got a problem with that. I realize that there are disparative sentences. I see it every day in the courthouse. And what I see mostly is a lack of effort or a lack of professionalism from defense attorneys, where they don't take the time, they don't put the energy in to make the argument to the prosecutor, make the argument to the judge. So I'll give you an example. Not too long ago, I had a case, and the prosecutor had offered me 5 years of prison on the case. It was a tough case, right? And we were ready to go to trial. And then I saw an article in newspaper about a case that I thought was a little bit more heinous. I'm just going to tell you it was a sex case, right? And I hate sex cases. I don't want to do sex cases, and I'm doing everything I can not to take sex cases. I basically reject them when they call the office now, right? There's plenty of attorneys that'll handle them. But anyway, my offer was 5 years of prison, followed by 5 years or 10 years of probation. I see in the newspaper, in the same jurisdiction that I have this case, another man who's charged with the same crime, but actually additional crimes, right? More serious crimes. The person was what referred to as a principal, meaning someone who's in charge of children. It could be a family member, it could be a teacher, a guidance counselor, a doctor, someone who is in a position of power that takes advantage of a minor. And I look at, so I'm reading this article, right? I'm reading the newspaper, and I see this article, and I'm like, what the hell? So I go onto the clerk's website, right? Same jurisdiction, and I look, and I see that this person was sentenced to years Florida State Prison. Two, right? And I'm going, wait a second. My case is apple, right? They both have the exact same charge, right? Except the one that got 2 years of prison, well, they had 2 more charges. Principal, right? And I don't want to give too much away, but another charge that's even a higher degree of felony, right? A degree higher. So obviously more serious case, obviously more sentencing points. So I found 2 separate cases in probably like a 2-month period. So what do I do is, and then you know what's even crazier? When I do my research, I find out that it's the same prosecutor. So you think I sit on it? Of course I don't sit on it. I write a very kind email. I say, I've located these 2 other cases. These cases, I understand facts are different because all facts and cases are different. But these other people have the same charges that my client has, right? Their charges are even higher than my client because there's additional. They have, like, my client had 3 counts. They had like 5, 6, 7, 8 counts, right? So they had more charges. So you would think they'd higher sentencing, but their sentence, not offered, their sentence was at least 3 years less. Well, the one case, 3 years less than my case. And I'm going, how the hell does that happen? So the prosecutor wrote me back and said, listen, that was because that attorney didn't fight the case, and right at case filing, the charges were discussed and a deal was formulated at case filing. The defendant admitted his guilt right from the beginning, basically entered a guilty plea, which is kind of crazy. And basically the prosecutor didn't have to work, right? And then the prosecutor says, Roger, you filed every friggin' motion on the planet. Like, you know, your stuff is so litigated. How many times have we gone to court on your case? You know? So I said, in my mind, I saw it. So then I send the prosecutor another case. And then right before trial, I go, listen, like, I know that there's a risk, right? My job is to protect my client, do everything I can to protect my client, to mitigate. So right before trial, like literally like days before trial, I hit this prosecutor up, I can't even tell you, like 100 times, right? And they would never budge from the 5 years and all the probation and sex offender registration, all that. Listen, prosecutor, I can't say the prosecutor's a bad prosecutor, right? The prosecutor is in a perfect position because they are very tough on crimes, on sex crimes, and this was a sex crime. And I think most society wants people that are tough on sex crimes. But there's different levels of culpability, even with same charges. So right before trial, the prosecutor finally gave us the deal. And it was, 2 years of straight prison. Now, if I hadn't seen those articles, if I hadn't been a thorn in that prosecutor's side, my client would have got 5 years. How many times can you ask someone, hey, Mom, Dad, can we go to Disney? Sorry, can't do that. Gotta work. Hey, Mom, Dad, can we go to Disney? Sorry, can't do that. Mom, Dad, can we go to Disney? Can't do that. Whatever it may be. Hey, prosecutor, could you do this? Can't do that. Hey, prosecutor, we do this. How many times do you have to ask the prosecutor to get them to do it? Now, remember, when you do this with a judge, right, and you do an open plea, you get one chance. You say, Judge, this is what they're asking. Here's the mitigating factors. And on an open plea, the judge can give you less. The judge can give you the same. The judge can give you more. I'm not a huge fan of open pleas. So when I go back in my mind of my experience, I do see disparative sentencing. I had a young man that reached out to me recently, and he had no prior criminal history. I'm just going to give you some examples of this disparative sentencing. And he had a concealed weapon, a firearm in his car, right? Now, I looked at, now the case had already been pled and he had like a violation of probation. So I just looked at it and I went, wait a second, what'd you get? And this guy got house arrest and a year of probation. And I go, okay. But on a gun charge, on a possession of a concealed firearm, no prior history, not a convicted felon, I've had that same case and got people into diversion. I've had that same charge reduced to a misdemeanor. The crazy thing about that young man's fact pattern was when I read the police report and it said that it was in the side cubby, right? It wasn't covered. It was in plain view. If someone looked, they could just see it. It wasn't hidden. So in my mind, I asked the client who called, I said, hey, did your attorney file a motion to dismiss on this? Because even these facts, you're allowed to transport a firearm, and if it's an open view, a firearm is an open view in your car, it's a misdemeanor. If your firearm is hidden and out of plain view, right? Out of plain view, it's a felony. So if you have a gun and you get pulled over by police, folks, you might want to say, hey, it's sitting right there on the thing. Don't stick it under your chair, under your seat, because it goes from a misdemeanor to a felony. All right. So I see it in this young man, a motion to dismiss, and I'm going, did your attorney file? He's like, I think so. I'm like, well, you would kind of know. You'd be sitting in a courtroom, and there would have been a motion, and you would have talked about it, and you might have signed an affidavit. Turns out this attorney never did that. And now I think about the last several cases that I've had with concealed firearms, and it's been a diversion, it's been a dismissal, it's been changed to a misdemeanor, it's been dismissed. So it really does come down to, at least one aspect, is attorneys, whether they're doing their job or not. If they're really fighting the fight and giving it everything they could as if it was their own child. Some do, some don't. Then you have, whether it's a tough judge or not a tough judge. So a judge that's very state-oriented goes, I don't believe everyone should have a firearm, that kind of thing. It's prosecutors that have that thought, and where you start, right? You got to go for the home run. So this whole idea of disparative sentencing, I get it. There is a disparity in sentencing, and there are arguments that it's race-based, right? It's based on the color of your skin, and I don't know if that's true or not, but according to studies, it's true, right? So, okay, let's go with the fact that it's true. Well, is this program, whatever it's called, that's going to give judges, hey, this is what everybody else gets? Well, what about when the facts are different? Are you now you're taking discretion away, but you're really not taking discretion away. You're just saying you're putting everything in a bottle. If you get this charge and you're pleading to it, you're getting this sentence. Is that in itself fair? What about a different factor? If you're just going, grand theft is 3 years of probation. What about the case where I think I talked about recently, the little old lady that walks into Nordstrom's and she goes to exchange shoes and they say, where's your receipt? She goes, oh my goodness, I forgot it, and walks back out the door. And has been spending, $10,000 a month at Nordstrom's because she was rich, but they arrested for grand theft. So in that case, when the judge came down and hugged my client and said, this is the lowest I can do, 1 day, court cost, withhold of adjudication and court costs, the judge wouldn't have been able to do that because the judge would have seen this whole thing and said everybody gets 18 months of probation on this. So now it's going to reverse itself and take the discretion out. So I don't know. I think this could be a huge topic where we have people talk about their cases. I think that it could be a huge topic where we have attorneys that come on. Everything you see is the law should be fair-handed, right? It should be equal. It should not vary. But the problem is facts vary. You don't have cases that are the same, right? There's no two cases like Johnny walked into Walmart and walked over to the detergent aisle and grabbed Tide. When you do case law research, you don't find the same patterns, right? Facts are different in every case. You get similar facts, but not like identical facts. And when you don't have identical facts, you're going to have some disparity. And also you're going to have some disparity. This CLE speaker talked about a really good fact. He said he had a case and he went to trial on it, and the judge gave his client 15 years of prison for a sexual encounter. It's another sex case. And then he looked at this program and he saw that the average sentence for the same crime was 2 years. He pulled up another case in the same jurisdiction with a more experienced judge who went to trial. The charges were the same, right? But the more experienced judge gave 2 years of prison versus 15 years of prison. And he said, listen, I know the judge that gave my client 15 years, he's not a racist. He's not, he's not a bad guy. He was just inexperienced and he had never done criminal law. And he was shocked by the cultural issues, right? That people would have threesomes and stuff like that. And so he sentenced this kid to 15 years. Now, obviously the speaker's telling his war story and he's saying it and he's close to it because as defense attorneys, you get close to your clients and you have to believe your client. You have to have that passion, right? Warm-blooded people, passion. So he's telling his story. His story was, hey, there was this young man, African-American man, got scholarships to 2, Division I schools, is dating a girl, her roommate, I guess the girlfriend talks to her roommate about how good he is sexually and these kinds of things. And there's actually an encounter where they almost all have sexual relationship, but doesn't go through with it. A couple months later, they have sex, meaning the roommate, not the girlfriend, and the girlfriend's not there. And then she says that she was raped. Well, he says, well, look, my client knew her. There was depositions taken. They were going to have sex in the past, right? He knew her. Then he gives an analogy of another defendant who is a maintenance man who knocks on a door at an apartment complex. He goes in. He sees a woman that he thinks is very attractive. He doesn't know her, and he holds her down and rapes her, right? And he goes, well, who should get the more sentence? He goes, the custodian who didn't even know the woman, he raped her, he got 2 years. My client knows the person. She had wanted to have sex with him in the past. Now she says that it wasn't consensual, and he gets 15 years after trial. Well, I don't know if I'm jumping into that argument like, well, he knew her, so that's okay. I respectfully have a hard time with that argument. I don't think well, Judge, one guy knew her and one guy did it. Reality is they're both raped. If the woman said no. So I didn't really like that argument, but that was the argument that he was making in his presentation about, who should get more time. And he said, well, he knew her, she wanted to have sex with her in the past. And I'm going, I didn't really like that argument, right? So his client got 15 years, the custodian gets 2 years. So disparative sentencing, if they start using this program, it's almost going to be like a minimum mandatory sentence. And then someone like me is going to have to challenge it and say, they're going to say, well, it's not mandatory, it's discretion based. But if you get all the judges jumping on board and they're just saying, okay, case versus case, right? All grand thefts get this sentence. And I know in a robotic world, then what's the sense? It'll be a checkout counter at Home Depot, right? I walk in, I get a bottle, it's $1.29. Well, you all know, right? When I buy this bottle at Publix, it costs like 29 cents. If I buy this at 7-Eleven, it costs $1.39, right? If I buy it at a concert or a football game, it's $7, right? Like you see, there's disparity in pricing, right? I go to gas station 1, it's one price. I go to another place, it's another price. There's always going to be disparity. So do we really want to fight these disparity cases, or do we want to be better in arguing, defending our particular clients? Do we want to maybe use some of this? Because I just think you can pull things like I did for my case. I pulled a newspaper article. I went to the clerk. I pulled the cases. I showed my prosecutor that, hey, you have cases that are worse than mine, and my guy doesn't even have criminal history, blah, 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 blah. And finally that changed. But you got to do the work. Now, if I start pulling, and I came close to this, folks, I came close to going to the clerk and ordering the records, because there is a way to do that, right? To get similar charges. But that's almost what this guy's doing, right? Shouldn't there be some discretion? Now, I don't want anybody, if your facts were identical, right? If your facts are identical, it just never happens. If your facts are identical, okay, same punishment. But your facts aren't always identical. So what's the difference between the guy who has a juvenile history and he's been adjudicated juvenile delinquent, he's been arrested for burglaries and armed robberies and carjackings, right? And that guy is now, I don't know, let's say 25 years old, so his juvenile history doesn't pop up, right? And then the guy who's 25 years old and he commits the same crime. Okay, so one's got history, never been in trouble, dropped out of high school. One's a college graduate, right? And was sitting in the car, and he's the getaway driver, right? Okay, so are there different facts? Should there be a different sentence? Should the court have discretion to do it? Yeah, I really think it's up to, and this is hard, right? Because the defense attorney has to do his homework. But I've had cases where a prosecutor won't budge for the whole time, and I'm like, this is ridiculous. I've had cases where I thought that the judge would do something fair in an open plea, and it's backfired. So how do you do that? Well, I think it comes down to the defense attorney. As a defense attorney, I have to be the guy with the most information. I have to be the guy that advocates for my client. I have to be the guy that just understands the facts, does case law research, pulls up things, hey, Susie, remember you had the same case with me 2 years ago, and this was the charge. What's so different about that case that you're giving me this? Well, your client had 15 robberies before his 16th robbery. Okay, well then I get it. But I think it comes down to the defense attorney really doing it. I don't think that we're going to have non-disparity in sentencing. I think what's going to happen is if this program, ERISA, whatever it's called, or I got to get the name and probably put it in the section. But if you're going to have this automatic checkout, then what? So what's the attorney arguing, right? They're already talking. You hear about this stuff? Guys, do a little bit of research on artificial intelligence, right? You have ChatGPT and stuff, and they're talking about computers that can already make legal arguments based on, I think they're doing it for traffic tickets right now. Well, traffic tickets, it's civil. Criminal, like there's facts. I mean, you can plug stuff into a computer, and a computer can definitely cite things, but do we really want, a cookie cutter checkout? Like just go through Home Depot. Okay, it's burglary, armed burglary. Okay, that's it. And you don't get to humanize your client, right? It becomes robotic. Do we want robotic sentencing in the name of non-disparative or, equal treatment under the law? I don't know, man. I don't think I want that. I don't think I want a situation where I walk in, or the client walks in and he's like, okay, I'm charged with my first grand theft charge. Cheek. And the computer, the robot, gives them, 2 years probation, every county in Florida. I think you got to humanize. I think there's diversion programs. And it's the advocates. As defense attorneys, we all have to be better advocates. We got to work harder to get this. I don't know. As soon as I started listening to CLE, and then I thought about how the minimum mandatory sentences are deemed non-constitutional because there's no discretion of the judge, I understand his argument. His argument is, hey, we're giving the judge discretion. You're telling the judge, well, it's between this and this, And that's what the whole purpose of the Florida guidelines are, the punishment code, right? That was the whole purpose of that, was to give equal sentencing. It's not perfect, folks. It's not a perfect system, but a lot of the disparative sentencing comes down to defense attorneys, prosecutors, that kind of thing. Let's see. I'm going to. Jesus, it's only 8:17 and always packed at the courthouse. Always packed at the courthouse. So anyway, I'll probably. There was a study out of Tampa about disparative sentencing. I had a colleague, Dr. Michael Brannon. I know he spoke at a judges conference a couple years ago. I know there's a big newspaper article about disparative sentencing, and there was a judges meeting. Like judges have training, CLE, and I know that Dr. Brannon spoke at that. I even asked him about some of the things that he spoke about because I was thinking about trying to use it in one of my cases. I don't know. I think everything being equal, sure, you don't want disparative sentencing, but man, I can't imagine where it's artificial intelligence and or because I think we're getting to that point. I think that they're pushing a system like, hey, you do this, you get this. Sure, that's strong, swift, but I think that there's going to be a problem, and I think that everybody doesn't fit into the same mold, and when you have that type of sentencing, that's what minimum mandatories were. Oh, you get a package at your house. Well, you get 7 years Florida State Prison because it was drugs and da-da-da. Well, the courts have already said that's non-constitutional. How long did that take? How many people went to prison on minimum mandatory sentences? I mean, just since I've been an attorney, I can't tell you how many cases I've seen of that. I've always been fortunate in making some arguments. Let's see. Oh, you got to be kidding me. I can never find a friggin' spot. Okay, all right, we'll figure this out. Got the new truck, so a little harder to park. I gotta get used to it. The one feature that does the automatic parking for you, the dealer didn't have that, or it was deleted when the person who ordered it, so it won't parallel park for me. And, well, I should be able to parallel park. My old truck I could zoom in and out with, but I've only had this baby for 2 days, so I think I may end up just parking in the court parking lot. But what do you guys think about disparative sentencing? I don't know, when you're watching this live, can you rewind and see what I've been talking about for the last 20 minutes or so? Tell me your thoughts. Tell me about your cases. Do you know cases where you've had a charge and someone else had the exact same charge and theirs was just lower? Of course, everyone thinks that's happening. There's literally not one parking space. I just circled the courthouse. Well, ooh, there's a spot right there. Can I get that? Ooh, that would be good. I would take that spot. If I could make a U-turn, but maybe I can get in there, but I know how these cars are, especially around the courthouse. You're trying to back up and parallel park, and these people ride right up to you and block you. You got to swing out a little bit when you... We'll see how it goes. Like I said, nobody. You know what it is? This is my turning radius on my new car. On my new truck is much different. I'm getting in here pretty good, I think. I do a video on my parallel parking. My Nissan pickup truck that I've had for 17 years, I can whip in and out because I'm used to it. On this F-150, it just seems, you know what also too? I think it's a lot longer. You find out stuff. Okay, so that's my spot there. All right, guys, I gotta go make arguments on my client. This is Friday. Well, today's Friday. Friday night law conversation. I'll talk to you soon. Put your comments in there and I'll talk to you about it. Subscribe. Thanks, guys, for watching. See ya.